Hi guys, welcome to my channel. My name is Diana Romanowska. I am a certified family law specialist practicing in the Bay Area, California. Today, I would like to share my reaction video about the series I started watching called The Good Fight. I had a blast watching it and I noticed some very common assumptions that are incorrect, and I just want to share it with you. Let's get started.
Okay. Here's the thing. I'm going. You're going now? No. I'm going to visit your dad. I don't mean that's non-negotiable. Why? There will be a moment when you tell a client for your own good, you have to do what I say. This is one of those moments for you. So I'll allow you to visit your dad in prison, but I'm going to be there. I'm going to hear everything you say to him and everything he says to you. So it's subject to attorney-client privilege. Do you understand?
This is so wrong. Okay, first of all, a daughter wants to visit her dad in prison, and daughter's attorney says, if I go with you, daughter, as your attorney, then everything you say to him is going to be subject to confidentiality. No. Why not? Attorney-client, when they have a relationship, they have confidentiality. The moment a third party enters into the conversation, the client implicitly, not explicitly, but it's implied consent to waive confidentiality. Because if I want to have a confidential information exchange with my lawyer, I don't invite the world. If I invite the world, that means I don't care about confidentiality. So what is this lawyer doing? Well, she wants to protect her client. She wants to join and go to prison, visit client's father, and listen everything they say so that daughter doesn't say anything incriminating, because lawyer's job is to protect her. But it's not confidential because father is not attorney's client, daughter is. So, that was surprising. She could have said, look, I don't want you to incriminate. She didn't have to push so hard and create a lie. And she could have said, I just want to protect you. I don't want you to say something that potentially could damage your case or our case. Anyway, so yeah. Anytime I have a conversation with a client and they have a mom, sister, brother, sibling, whoever on the phone, I say, you waive your confidentiality. In fact, I can be subpoenaed and have to testify what I told you in this conversation, not just the client. By client allowing third party to be there, I'm exposing myself to, it's not confidential. All right, moving on to the next clip.
Are you kidding me? By who?
Christina, can one of you point me in the direction of a Ms. Luca Quinn? Good luck with the grand jury.
All right, so this is a situation where I don't like to be a process server because they have a tough job. Basically, how do we personally serve someone? And in all movies, I see this same common misconception. Oh, you're Mr. Smith, you have been served. No. If I have a picture, if I'm a process server, a process server, if they have a picture, they don't need to ask the name. They know who this person is. And if that person doesn't want to take the paper and says and holds their hands, guess what? A process server can dump the paperwork on the ground and it is considered personal service. So, however, what happens if the person stands with other people? Well, it's helpful to say, Mr. Smith, you have been served. Them, drop the paper on the floor, or give them, if they don't want to take it, drop it on the floor, and give them if they can take it. But You cannot just run, drop the paper and run. So it has to be clear that this person has to pick this up somehow. If you look at the form FL115, it's the form we use, proof of service of summons. So basically, if we have divorce paperwork that we need to serve, the summons needs to be served, and usually we serve other paperwork, which includes FL100, petition for divorce. Now, if you look at number 3, it says personal service. So whoever is serving, usually professional process server, they have to fill out this form, and they have to say a date and time, their name, and the license number. And their proof of service, their declaration is presumed to be correct, meaning the burden of proof shifts to the other party to prove that I haven't been served. For example, if someone runs and drops a paper, you didn't notice and you were with a bunch, how would you know? So then you have to file a motion to quash within 30 days from this alleged service. Sometimes there is a substituted service. I use that for businesses. So if I have to serve someone, let's say an attorney, and I cannot serve them by email because they didn't accept it, I cannot serve by mail because it adds 5 days that I don't have, and I need to serve them now, what I do is I go there or send a process server and deliver the paper to either the secretary or to the business person. Even if they're not there, it's considered personal service. It's called substituted service. In business, a person at least 18 years of age who was apparently in charge at the office or usual place of business of the respondent. So that's that. And home is a competent member of the household at least 18 years of age at home of the respondent the other side. So that's how personal service is done. Don't have to say, you have been served, Mr. Smith. All right, my final video.
What?
A temporary restraining order. By order of the Cook County Circuit Court, you must immediately cease generating false news about Meyer and Dow until a hearing can be held on the merits of her case against you.
You don't know much about computers, do you?
I know now.
Cook County Circuit Court has jurisdiction only in Illinois. I bounce my encrypted software through servers in 20 states, Mexico, and Japan. Cook County Circuit Court can't enforce this order. No jurisdiction.
Where respondent resides. So this guy thinks he's a smart cookie because he operates in all states and everywhere in the world, internet, right? He harasses people on the internet. Well, but he resides in that state, meaning he can be served, and the court does have personal jurisdiction over him, even subject matter jurisdiction, meaning because he operates business from where he lives, so he's wrong. The court does have jurisdiction over him. In cases where someone, I had a case where there is an act of domestic violence committed in another state and that person runs to a more favorable state and files a restraining order. The court could say, because the witnesses and everything else happened in that state where everything happened, I'm not going to have subject matter jurisdiction. Personal jurisdiction over the abuser potentially, but not subject matter jurisdiction. Something to keep in mind. Love, love, love this series. So I'm excited to share more reaction videos. And if it was helpful, click like, subscribe, and I'll see you soon. Bye!